I'm Christina, the director of the Pennsylvania Parent and Family Alliance. The Parent Alliance supports parents of children with mental health challenges, whether they are diagnosed or suspected. And we work with parents anywhere in the state of Pennsylvania. I want to give a disclaimer. We are not lawyers, so the information we're providing is not legal advice. This presentation and our tip sheet have been reviewed by appropriate legal people to make sure we're providing accurate information, though. And also, the information we will be discussing today does not apply to substance use treatment. They have their own regulations. We won't be covering that. Okay, so as we're getting started, let's take a second to talk about our use of the word voluntary in our presentation. We are talking about a choice made by parents, primary caregivers, or the child themselves. Now, many of you may have heard of a 302, Section 302 admission, and that's when someone is an immediate identified threat to themselves or others, and their treatment is mandated by like the police or court. Voluntary treatment is not a 302. They are very different things. And we're saying voluntary even if the child doesn't agree. So it's not mandated by some legal authority. Now, we are able to be here today because of one mom's tireless efforts to ensure that parents are able to act in the best interest of their children when they need help. April Dugas's daughter, Gabby, developed a severe eating disorder and became suicidal after experiencing a major trauma in high school. April was over 14 and she said she didn't want to go into treatment, and Gabby's concerns were ignored. She was told wrongly that Gabby's refusal for treatment was the final word. Now, after her daughter's death, Ms. Dugas approached her local representative to ask for solution, and it was a long and hard fight. But Act 65 became law in 2020. It is definitely a testament to a mother's love and the importance of parent advocacy. And I always like to start by taking a moment to think of Gabby and to honor April for her efforts. So our plan for our time together is to read the law as it's written. We're going to check for understanding along the way. We'll discuss the most often asked questions and finally wrap up with some repercussions for children when the law isn't followed. If you want to read the law yourself, we do have a link to it on our mental health consent page, and you can scan and read the cleaned up, easier version of the law. It's still the law exactly as it was approved, but it's without all the changes and stuff. So it's a little cleaner and easier to read. And I do want to mention, if you have any questions, feel free to ask those in the Q&A as they come to you. Chances are we'll probably cover them, but there's absolutely nothing wrong with asking anyway. We'll be really happy to answer as our time allows at the end. And even if we don't get to your question, we're happy to follow up with you afterwards. Okay, outpatient treatment, section 1. The following shall apply to consent for outpatient treatment. A minor age 14 years or older and parents' consent is not necessary. A parent or legal guardian of a minor less than 18 years old may consent to voluntary outpatient mental health exam or treatment on behalf of the minor, and the minor's consent shall not be necessary. A minor or another parent or legal guardian may not abrogate consent provided by a parent or legal guardian on the minor's behalf to voluntary inpatient or outpatient mental health treatment, nor may a parent or legal guardian abrogate consent given by the minor on his or her own behalf. Now, like abrogate is one of those legal words that we wouldn't use in our daily conversation. So let's just take a minute and go over it. It's a verb. It means repeal or do away with, specifically like a law, a right, or a formal agreement. Used in a sentence, it would be a school district may not abrogate the state mandate to begin transition planning at age 14. So some other words that you could use: revoke, repeal, overturn, overruled. So let's read that again and use some plain language this time. A minor or another parent or legal guardian may not override consent provided by a parent or legal guardian on the minor's behalf to voluntary inpatient or outpatient mental health treatment. Nor may a parent or a legal guardian override consent given by the minor on his or her own behalf. Okay, so let's make sure that that makes sense to us with just a few quick knowledge checks. Here we have mom and dad. Their child says, I want to go see a therapist, some other form of outpatient treatment. And the parent goes, listen, you've been watching too many TikToks. You don't need to do that. Can treatment begin? Yes. Section 1.1 makes it very clear once a child turns 14, their parents' consent to outpatient treatment is not necessary. Let's look at it the other way. Mom or dad say, we're concerned. We'd like you to see someone who can help. And the child says, nope. Now, you'll see that it's listed any child up to age 18. And that obviously includes those tricky years in question, right? 14, 15, 16, 17. Can outpatient treatment begin on mom or dad's say so when their child, even those in over 14, are saying no? Yes, treatment can begin. Again, Section 1.1 explicitly says parent or legal guardian of a minor less than age 18 may consent to voluntary outpatient treatment without their child's consent. Okay, people ask all the time, what if the parents are divorced? So in this case, let's say mom wants her child to go to treatment, dad doesn't. And we'll even say the child themselves doesn't want to go, right? It doesn't matter if the parents have never been married, are still married but disagree, are separated, or divorced. If one parent wants their child to seek treatment, can treatment begin? Yes. Section 1.3 says a minor or another parent or legal guardian may not abrogate, in plain language override, consent provided by a parent or legal guardian. Okay. And you'll notice that it says in section 1.3, inpatient or outpatient treatment. So parents cannot override each other. Okay. Last scenario for outpatient treatment. In this case, we're going to have the parents, again, not in agreement. One parent says yes to treatment, and for good measure, we have the child agreeing too, but another parent saying no. Can treatment begin? Yes. Again, section 1.3. Nor may a parent or legal guardian override consent given by the minor on their own behalf. So, quick recap for outpatient services. Only one person needs to say yes, and treatment can begin. Once someone says yes, yes to treatment, no one can stop treatment from happening. Okay. Now, inpatient treatment is just a little different. A minor's parents or legal guardian may consent to voluntary inpatient treatment on behalf of a minor less than 18 years of age on the recommendation of a physician who has examined the minor. A minor 14 years of age or older may consent to voluntary inpatient mental health treatment on his or her own behalf. And again, neither party may abrogate consent provided by the other party. So what's new in this section is that parents can consent to voluntary inpatient treatment with the agreement of a physician who has examined the child. Now, that's not a big deal. Anytime you need to be admitted to a hospital, someone has to examine you. You can't just show up and go, I hear the beds in the third wing, blue wing room, ward, whatever, are great. No, everybody has to be examined. So this is no big deal. A parent or legal guardian who provided consent to inpatient treatment may revoke that consent, and inpatient treatment will continue if the minor has provided consent. A minor who has provided consent may revoke that treatment, and treatment will continue if a parent or legal guardian has provided consent. All right, so let's check and make sure we get that part too. For inpatient treatment, we have parents who initially agree to admission and a kiddo who's like, nope, I don't want to go. Now, after a bit, the parents are feeling some kind of way and change their minds. But now their kiddo over 14 says, I want to stay. Can treatment continue? Yes. If you provide consent, you're not stuck with it. You can change your mind. But if someone else steps in or has already agreed to treatment as well, it can continue. Once again, it just has to be one person, and that one person could be the child as long as they're over age 14, right? Okay, now there is protection for a child should they feel that inpatient treatment is not appropriate. And this is great because we want our children to be aware of their rights so they're informed and can exercise them. At the time of admission to an inpatient treatment facility, a representative from that agency will talk to the minor and explain the nature of the program. A statement of the minor's rights to object will be explained along with a written copy. If the minor wants to exercise this right, the director of the facility will provide the minor with a notice of the request for modification or withdrawal from treatment form, and a representative from the agency will file that signed petition with the court. After it's filed, the court will promptly appoint an attorney for the minor, and a hearing will be scheduled to be held within 72 hours following the filing of the petition. Now, what I want to point out is that a child can exercise their rights at any point in their treatment, upon admission, 6 months in, 2 years in. There's no time limit where they have to say, I don't want to be here. So the big question is, where is the minor during these proceedings? The minor remains in the treatment facility until a judge or mental health review officer determines if the mental health treatment is in the best interest of the minor or not. Now, the law talks about the specifics of what must be provided to the judge or review officer in order for them to make that decision, and providers can find those details as necessary. So, how long can a child be held for treatment? A minor ordered to undergo treatment will remain and receive inpatient treatment for up to 20 days. A patient may be discharged when the attending physician determines that the minor no longer needs treatment, or at the end of 20 days, whichever comes first. If at the end of the 20 days, the attending physician determines continued inpatient treatment will be necessary and the minor does not consent, the court shall conduct a review hearing to determine whether to release the minor or make a subsequent order for inpatient treatment for a period not to exceed 60 days. Now, this cycle just goes on and on until either the doctor feels the child is no longer in need of treatment or the child agrees to treatment voluntarily. Then if a child changes their mind and says, I want to be here, they don't have to go back to the judge. Now, sometimes yeah, it happens. Sometimes they get into treatment and they realize that, like, wait, this is not what I saw on TV, or maybe it is really helping and it changes their mind. And that's fantastic. Okay, quick inpatient recap. Yes, a parent can consent to their child's inpatient mental health admission. An admitting physician is necessary. No, a child over 14 does not have to agree in order to be admitted. Yes, once a child turns 14, they can give consent to their inpatient admission. And yes, a child has protections if they are admitted to an inpatient facility and feel like they don't belong there. Now, when there is a disagreement between parents about inpatient treatment, the child stays where they are, and the non consenting parent, the parent who doesn't want their child to have inpatient treatment, has the obligation to request a hearing where the child lives. Both parties do not have to agree in order for treatment to start. We get that question all the time. Remember, for both inpatient and outpatient treatment, no one may abrogate or override another's consent. Now, does it matter if the parents are divorced? I mean, in most divorces, it's likely that they have shared medical decision making. That's pretty standard in a divorce decree. But that doesn't change the fact that according to Act 65 of 2020, only one party has to agree to treatment, inpatient or outpatient. If a parent really disagrees to inpatient treatment, they can petition the court and leave it to a judge. So let's look at a disagreement recap. There are no legal options for settling disagreements between parents for outpatient treatment. A parent disagreeing with the other about inpatient treatment does have legal recourse, and there are no options for parents to disagree with their child's consent to any treatment. Now, let's face it, our children know what's going on inside their body, and we need to respect that. And talking to a therapist can be a good thing. So, we really want to support our children if they say, I'd like to talk to someone. Okay, so let's move on to medical records because this is a tricky area. A minor may consent to the release of the minor's medical records and information to the minor's current mental health treatment provider. A parent or legal guardian may consent to a minor's medical records and information be released to the minor's primary care provider if such release would not be detrimental to the minor. And information will be released from one professional directly to another. Okay, so this is where it gets tricky. When we're talking about mental health treatment, no matter your age, what you say in treatment is always confidential. Okay, with a few exceptions. It's important to talk to your child about how therapy works. What they tell their therapist will not be shared with you. Yes, we want to know what's going on with them. Why are they sad? How can we help them? And that's something you can talk to your child about after they get settled into treatment. You can start by asking how you can support your child to get better. Now, initially, the child may not know why they're so sad, so some of these answers may take a while. If you're taking your child to a therapist, especially if your child is resistant, ask that that first meeting include you so you can ensure your child, with the therapist there, that they're not gathering intel to report back to you. If you have to take your child to an ER for a mental health emergency, stay with your child. Insist you get all copies of paperwork and that you're allowed to sign anything they sign. Go full Karen on them if necessary, because this is really, really important. Parent or legal guardian who is providing consent for the minor to receive mental health treatment shall have the right to information necessary for providing consent to the minor's mental health treatment, including symptoms and conditions to be treated, medications and other treatment to be provided, risks and benefits, and expected results. Listen, we've actually heard of hospitals refusing to tell parents that their child is even in the facility where they were dropped off. And this is unconscionable. Ownership of records can be really confusing. It depends on who gives consent to treatment. If the parent gives consent to treatment, then they can get limited information. If a child over age 14 gives consent to treatment, the child has to agree to their parents to get information, and they can change their mind. And the regular rules for patient doctor confidentiality always apply, even if the parent gives consent. Parents do have the right to basic information about what's happening with their child in order to make the determination whether they want to provide consent or not. And doctors can use their professional judgment to determine whether to release information to the parents if they're concerned about abuse or other mistreatment. Now, we get reports from parents all the time about being completely locked out of their child's treatment. Parents hear that they can't be told what their child's diagnosis is, what the treatment plan is, what medication their child is being prescribed, or what follow-up treatment their child needs. And there's absolutely no reason for any of that. And it is actively harmful for the child. Let's take a quick look at why. While the child is receiving inpatient treatment, their parent has to communicate with the school to explain their absence. If they don't, they're likely going to be look at truancy charges, and schools do not accept random 14-year-olds calling themselves off. Once a child is discharged and has a diagnosis, their parents can go into school, ask for a 504 plan, or even an IEP if they don't already have one. If they do have an IEP, the parent may need to work with that IEP team to get it revised, but they can't do this without that updated diagnosis, an understanding of what that means and what their symptoms are and how they'll likely manifest. Let's talk about medication. It's likely a child is going to need some kind of medication upon discharge. What should a parent be looking for in terms of adverse reactions? How can they do that, especially if they don't know what type of medication their child is being provided or how they're supposed to take that medication? Like, are we expecting our 15-year-old child to be able to remember on their own what time to take their medication every day, whether they need to take it with food or not? Is the hospital teaching the child how to manage their refills and what to do if there's medication shortages of what they've been prescribed? Right? Parents are responsible for managing those things. Now, also, parents often reach out to their child's school to let them know we're trying out a new medication. So maybe they'll be a bit more tired, or maybe they'll have dry mouth. So they're going to need to be able to go get a drink every so often. And it's not just an excuse that they're using to get out of class, right? Parents are going to need to know if their child suddenly stops taking the prescribed medication and what might happen if they do. So, yes, a child can agree to their own medication, and that's fine. But parents are still going to be responsible for helping them manage that. And it's probably best that you, as a provider, make sure parents understand the value of taking that medication and the importance of taking it. And finally, let's talk about treatment. For parents new to mental health concerns, they may not know that getting treated for a mood disorder or other mental health challenge isn't like fixing a broken arm or getting a diagnosis of diabetes, right? Treatment takes a long time, and there's really no clear cut regime where you take X amount of a standard medication so many times a day, depending upon what a test tells you. Wait lists are long, insurance is confusing, and commercial insurance often doesn't cover the ongoing treatment a child needs. And let's not even get me started on wait lists and getting in to see providers. Without parents on the treatment team, follow up is really unlikely to happen. Now, for the majority of children, parents are their lifelong safety net. They're going to be there to fill in the gaps when the system fails and can't meet their need. So, bringing a parent onto the treatment team in an appropriate fashion is critical for a child's success. Nothing in the law prohibits a child from being told their child's basic information. And look, I get it. If a child is diagnosed as being depressed because they're gay, and that's not likely to go over well at home, it can be hard. So, you tell the parent their child is depressed and leave it, but not including the parent in the treatment plan, not understanding and giving them the basics is not going to be helpful for the child and may actually harm them, as we've seen. Now, I want to give parents a few pointers here in case you're in this unfortunate situation where your child is in a crisis and you find yourself at the ER. If you're told that they will not admit your child over 14 without their agreement, want you to launch into full note taking mode. Want you to ask why. Why does my child need to give consent if I'm providing my consent? Write it down. Write down their answer. Get their name. Is this a hospital rule? Is there a place where I can find that hospital rule? Is it what the doctor's saying? Can I talk to the doctor? Ask the doctor where they're getting their information from. Are they citing HIPAA, a random law, or a hospital policy? Ask what it is. We have parents who have actually had success pulling up Act 65 of 2020 information and sharing it with the hospital staff. But at the end of the day, if your child needs help, your main priority is to get them that help so you get your answers and then you go back to focusing on your child. Can you talk to them, ask them why they don't want to agree to staying? What are they afraid of? Often doctors use language that our children don't understand, especially when they're already not thinking clearly. Do your best to talk your child into providing consent. You may be able to leverage the fact that they don't want to be involuntarily committed, and it's best if they agree. If they have to be 302'd, it's unfortunate, but at the end of the day, they'll get the treatment they need and they'll be safe. That, of course, may not be an option, and you're left trying to get them to agree. If you can't, you can always try another hospital that knows and follows the law. Or give us a call the next day. We'll do our best to help you fight with your hospital or brainstorm other ways of getting them help. And really important, of course, the new 988 number for mental health emergencies can be very useful. So give them a try in the moment. Okay, I see we have time to do a final knowledge check. So let's take a minute. Scenario one. We have a therapist who's been working with 14-year-old Abby concerning her eating disorder. They've been working together for 6 weeks. It's the longest Abby has stayed with any therapist. Abby is on the verge of a breakthrough and doesn't want to go any further because she's uncomfortable. She wants to fire her therapist and quit therapy. The therapist feels that Abby is exhibiting avoidance of the issue at hand. The therapist feels that if they can continue to work together, a breakthrough will happen. And we know that Abby has fired her last three therapists, but her parents want to continue her treatment with this therapist. Based on what we just learned about consent, does Abby have the right to refuse treatment? No. Again, if one parent even provides consent for treatment, it doesn't matter that the child does not provide their consent as well. The child does not have to be in agreement for therapy in order for it to begin. Both parents don't have to be in agreement for therapy in order for it to begin either. All right, we're going to look at it a different way. We've got 17-year-old Alyssa, with the help of her school guidance counselor, has sought out patient therapy due to her feelings of anxiety. Her father's aggressive behavior and verbal altercations with her mother make it impossible for her to even think when she's at home. After the first month of outpatient therapy, dad finds out. Dad is furious and demands that Alyssa terminate treatment. Does Alyssa have to stop therapy? No. Again, Alyssa doesn't have to stop treatment. She's over the age of 14. She's given her consent. And once that consent is given, no one may abrogate or override it. Okay, let's look at inpatient treatment. 16-year-old Jacob is in need of a residential treatment facility due to his sexually problematic behaviors against his 10-year-old sister. Jacob does not want to go to a residential treatment program and has agreed to remain in outpatient treatment. Now, after speaking with Jason's therapist, mom agrees that a higher level of care is needed in order for Jacob to make progress. While searching for the proper RTF, mom is told over and over that because Jacob is 16, he will have to agree to voluntarily to going to an RTF. Does mom have the right to sign for voluntary placement for Jacob? Yes. Remember, nothing in Act 65 of 2020 says a child can override their parents' consent. As a matter of fact, it very, very explicitly, repeatedly says exactly the opposite. It reiterates over and over again that a parent can give their consent to mental health treatment for their child all the way up to the time they turn 18, over and over. They say it again, no one may override consent once consent is given by any party. Okay, in summary, Act 65 of 2020 allows a minor age 14 and older the right to consent to mental health treatment. Parents, as always, have the right to consent to mental health treatment for their children until they turn 18. No party may abrogate the consent of another. Non-consenting parents or legal guardians of the minor may object to inpatient treatment through court. Release of medical records and information can be requested by either parent, legal guardian, or by the minor, and basic information may be released to the parent or legal guardian. No one expects you to become a legal expert about mental health consent, so we've created an entire page, again, on mental health consent, which includes this downloadable tip sheet, English on one side, Spanish on the other. Again, a recording of this presentation, and the direct link to the law itself are all available on our mental health consent page.